Good morning, ladies and gentlemen.
Good morning.
Morning.
Well, thank you, Your Worship. I'm pleased to see you this morning, and Mr. Semuyaba and Faith, as well as my colleague, David Sigano. Ladies and gentlemen, I'm pleased this morning to welcome you to yet another session on the East African Court of Justice. On behalf of the Governing Council of the East African Law Society, receive greetings from Mr. Willie Rubea, the President of the East African Law Society, as well as the other members of the Governing Council. So receive greetings from our Secretariat based in Arusha. Ladies and gentlemen, as you've seen from the early invitation, this particular session will be focusing on drafting lessons on pleadings coming before the East African Court of Justice. And the reason why we are choosing the area of drafting is out of experience. We've noticed that increasingly the court is relying a lot on documentary evidence and documentary records. More and more, as justice processes transform on use of technology, the court is going virtual, and there's less use of oral pleadings before the court. And that calls for meticulousness and calls for putting and setting cases in the most open, precise, and understandable manner. And as you know, not just at the East African Court of Justice, even at the domestic courts, at the moment, if your records, if your documents are not pleaded properly, then you are already one leg out of the case. And that's why we saw the importance of having this sort of a masterclass just to start us off. In future, we will be listening keenly to what your feedback will be, so that in future we could improve, we could focus on other areas also. But to bring to you the team that is going to assist us this morning, we start off with Honorable Euphlanis Okubo. Honorable Okubo is the Registrar of the East African Court of Justice, the custodian of the administration of the court, the custodian of the memory of the court, and your point of interaction with the court. Your very first point of interaction with the court is usually the registry, which he heads. You might not meet him in person. You might meet Boniface and other registry officials, but I can always assure you that no matter gets to the registry before it passes through the hands of the Honorable Registrar, and is hands-on when it comes to court processes. For those of you who've attended the EACJ court session, you will always see him starting off, guiding court users on how to go about. And whenever you need assistance, even with their documentation, he is always at hand to assist. Welcome, Registrar. The other person is Justin Semuyaba, an advocate based off the Republic of Uganda. Justin is a regular face at the East African Court of Justice in Arusha. At times, I actually wonder whether he's already received his residency permit to stay in Arusha, because 3 out of 5 days in a week, you'll find Justin at the East African Court of Justice. He has a hand in almost 50% of cases emanating from Uganda reaching the East African Court of Justice. A seasoned hand, experience at the court processes, and a prolific drafter. And we will be feeding from his well of experience. And finally, Faith Masharia. Faith is a partner at Anjarwala and Kana, probably the foremost leading law firm at the moment in East Africa, with offices across each and every member state of the East African community. I'm not very sure they are now grounded in South Sudan, but I know Anjarwala and Kana has been trying to make inroads there. Faith practices before the East African Court of Justice. Faith does preeminent litigation at Anjarwala and Anna, and with wide experience in commercial litigation and arbitration, Faith has already cut a niche for herself as one of the leading and frontal practitioners before the East African Court of Justice, especially on the matters of enforcement of customs union, as well as the common market protocol. And Faith will be sharing with us basically on how to perfect pleadings. Mr. Semuyaba will be discussing with us generally about pleadings before the court, the nature, structure, and content, while Faith will be adding flavor to that by basically drawing onto the common knowledge that we all know and on how to ensure that our pleadings are well understood and precise before the court. I will invite the registrar to start us off by giving us a general overview of the court. He will also take us through some of the salient rules of the court and how they play out within your pleadings. How do you plead? How do you ensure that you stay within the rules while doing your drafting? And that's, ladies and gentlemen, is the beginning of our discussion. Please stay alert. While your mute button, your speaker's button is currently on mute, ladies and gentlemen, you have the Q&A on the chat board. You also have the chat tool that you can always use to send whatever remarks you want to send across. And at the very tail end of this session, we will be addressing each and every contribution that you've brought on board. Please feel welcome. Thank you. Mr. Registrar, please start us off. Thank you.
Thank you, Hannington, Semuyaba, and Faith Macharia. I'll be taking you through the rules of procedure as far as pleadings are concerned. For some of you who are aware, we recently published new rules of the court 2019 that were amending the previous rules. So I'll not go through each and every rule because the rule ran to more than 200 provisions. Even if I were to take a minute for every provision, not all those provisions relate to pleadings. So I'll only stick to the provisions that relate to pleadings. Just a minute. Let me just correct something. So, looking at the rules, you'll find that they provide for preliminary provisions, the general powers of the court, the registrar and the registry, the documents, appearances, court sessions, and pleadings. Mainly pleadings start from Rule 11. But before one undertakes to file a matter in this court, it is important to refer to the treaty. Confirm and be satisfied that you have a cause of action. Otherwise, you might find you're filing a case that gets knocked out on a technicality. And there are many things to consider. For example, one of the things that is so important to consider is whether your client can actually institute a case in the East African Court of Justice. For instance, if he is not a resident within East African community, then he cannot file a case in the EACJ. That is just one of the things to consider. Another important factor that you need to consider is the limitation period. Apparently, the limitation period of this court is 60 days and Article 32. Very limiting, of course, but there it is. And the problem is that it is sort of cast in stone because it is specifically mentioned in the treaty. So for you to go outside the 60 days, then you must amend the treaty. I can tell you we have lost very many good cases because of the limitation period. Now there are different types of pleadings that end up in courts. Some of them are the reference, which is almost like the plaint, the response to the reference, which is like a defense, reply to the response to the reference. Then we have what we call claims, the defense to the claims, advisory opinions and case stated, which I will not deal with it so much because we have had very few experience on that. Then of course we have the common one, which most of you are familiar with, the notice of motion, supporting affidavits, affidavits in replies, affidavit of service, notice of appointments, and notice of change. I'm mentioning this because these are the ones which lawyers, practicing lawyers, have to prepare, have to file. There could be other documents that are generated by the system, which I need not mention here because then they are not, in as much as they are pleadings, they are not generated by the councils. Now, Rule 11 talks about the preparation of the documents. An important thing, which is that the documents have to be in the official language of the courts. Now, in those pleadings that you'll notice that every document has to be numbered consecutively and bound in a book form. All that is provided for in Rule 11. Then again, another important thing in our pleadings is that the documents that are attached to your pleadings, which then become pleadings also, every 10th line of each of the pages have to be indicated on the right-hand side. Then all pleadings, as you draw them, I'm sure Semuyaba and Faith might go into details of these, will have to be divided into paragraphs, numbered consecutively, and each and every allegations to be on a separate paragraph. If there are dates, sums, those have to be expressed in figures and not words. And of course, we indicate the address of service of the party making it, signed by either the applicant or the advocates. But if all the above mentioned in Rule 11 is not complied with, the registrar has a right to reject those documents by failure to comply with what I've just stated under Rule 11. Another thing that I might mention here is that you may find there are situations where you are given time within which to file a document. For example, within 14 days, this document has to be in. In the event that the document is being filed late, we do not reject. We always accept, but it is stamped, lodged out of time, so that the courts and even the other side is aware that this document was lodged out of time. Rule 17 is a normal practice that after service of every pleading, the serving officer shall swear an affidavit of service. So the affidavit of service becomes a pleading stating where it was served, the manner of service, name of the person served, and how it was identified. We have a sample of that in the second schedule of our rules, prescribing our formats. But then in these new rules, if you refer to Rule 132 and 133, that is why we provide for electronic service. You'll find that is slightly now different from the normal way we know of serving and preparing an affidavit of service. We are just upgrading our system so that you can be able to serve online through our system. Now, the way we are doing the system is that if you are served online, when you open your email, it automatically generates an affidavit of service saying the date and the time within which you open your email, which then shall be evidence that service was effected. Rule 19 provides for notice of appointments. Again, this is a document that is prepared by the councils if you are appointed to act for any litigants. Rule 12, also a notice of change, that is a pleading common. And remember, all these documents you're talking about, as you draft them, you have to refer back to Rule 11, what I've just mentioned as we were starting. And then advocates who are appearing, especially those that are appearing for the first time in that particular year, you need to attach a copy of your practicing certificate. It is not easy for the court to know whether this lawyer is entitled to practice or not. So if it is the first time you're appearing in that particular year, then you attach a copy of your practicing certificate to show you're entitled to practice in your jurisdiction or to appear before a superior court in your country. Rule 25 provides for how a reference should be filed. Of course, it is lodged in the court, a statement of reference is filed. It will contain the applicant's details, the respondent's details, the subject matter, the points of law and nature of any evidence in support, plus the relief sought. These are common issues in any litigation. But where in that reference you are seeking to challenge the legality of an act or a regulation or a decision or action, then you need to attach a copy of that act or regulations through an affidavit. You introduce that evidence through an affidavit. That will be provided by Rule 25.3. Rule 25.4, if it's a body corporate suing, how does the court know this body corporate actually exists? So that body corporate will have to attach either the certificate of incorporation. If it is, let's say, a state corporation, then a copy of the Gazette notice that created that state corporation, or even just a copy of the act, the beginning, they establish the provisions that created that body corporate, so that the court is satisfied, yes, this person or this company coming before us is actually an existing body corporate. Rule 26 provides for disputes between community and its employees. Now, this is where claims come in. Remember, we've been talking about a reference, and we also said there can be a claim. Where a staff member sues the community, it's called a claim. Likewise, the claimant will state the concise statement of facts which the claim is based, the applicable law, and the orders the claimant is seeking. Now, going to Rule 22, now this is the response to the reference or a defense, which has to be done within 45 days after being served. Likewise, it will contain the name and address of the respondent, the statements of fact, any law being relied upon, any nature of the evidence which will be supporting their case, and relief sought by the responses. More often, of course, it is always they are seeking for the respondent to be dismissed with costs. There could also be a reply to the reference which will be filed by the person who filed the reference within 45 days after service. So a reference is filed, it is served on the other side, the other side files a response, and then the person who filed the response has a right to reply to the response. Rule 33 talks about, provides for defense and counterclaims where applicable. And these have to be served within 30 days. Likewise, the name, address of concise statements of facts, the law relied upon, the nature of evidence, just like we've talked about the other documents. But where a counterclaim is filed, and there is an admission or denial of the facts stated in the claim, any additional documents to be relied on and the order sought will also have to be stated. Rule 35, I believe my colleagues will talk in details about this, is very, very important, and we have had a lot of problems pertaining to the provisions of Rule 35. It says facts and not evidence are to be pleaded. This creates a lot of confusion from some jurisdictions. You find a very huge document has been filed as a pleadings. When you read the whole of it, 90% of what has been filed is evidence. My colleagues, I'm sure, will go into details about that. Why facts and not evidence has to be pleaded. Then Rule 36, there are certain matters that have to be specifically pleaded in the pleadings. For example, particulars of misrepresentation or fraud. All of that has to be specifically pleaded. Now, Rule 37, you annex to the originals of every pleading certified copies of the relevant documents in support of the contentions contained in the pleading. This is now like introducing evidence, which you attach to the pleadings, as an annex. But again, as you proceed, you cannot make a departure from the original pleadings. So you may not make an allegation of facts or raise new grounds of a claim that are inconsistent with what is in your previous pleadings in the same matter. It will be introducing together. It may raise issues of jurisdiction that were initially not contemplated. Rule 43, pleadings close 14 days after service or 15 days after the response to defense. That is also again a common practice. And once the pleadings are closed, there will be no more filing, save with the leave of the courts. And of course, pleadings must be signed by the parties or the advocate for them to be genuine. Rule 47 provides for striking of pleadings. Now this is where now we're introducing the notice of motion. So remember the type of pleadings to be filed in court that I mentioned earlier there. A reference, a response to reference, claims, but all application to EACJ come by way of notice of motion with a supporting affidavit. So the grounds for striking out are stated there: common ones, scandalous, frivolous, vexatious, and appeals of the process of court that we always see every day. Then Rule 48 will provide for how to amend the pleadings. There's the general power and the amendment with the leave of the court, or amendment with the consent of the parties. Again, this is an application. That means it comes by way of notice of motion. Rule 52 now talks about the notice of motion, supporting affidavits, affidavits in reply, how a notice of motion should be formulated. Rule 59 talks about intervention. Again, to apply as an intervener, you come by way of notice of motion. Once all the pleadings are closed, then we go to scheduling conference. Whatever will come out of the scheduling conference, whatever will have been agreed in the scheduling conference, that becomes a pleading, because that is where the issues will have been framed. In those scheduling conference, they will show points of agreements or disagreements, possibilities of mediation, if there is potential for settlement, or if the matter should proceed to hearing, how many days the matters will proceed for hearing. Rule 83 provides for an application for review of judgment. Again, because it is an application, you come by way of notice of motion. Of course, the grounds for notice of motions are well stated and well known. Then Rule 88 provides for pleadings when it comes to the appellate deal, which has to be done 30 days after the date of the decision. After that, part of the documents you need is the decree or the order that need to be extracted before lodging the appeal. Again, we have had a problem here. We have had situations where an appeal is filed, there's no decree, and there's no order. The result of that is, of course, the appeal collapses for lack of the order or the decree appealed again. Rule 89 provides that for the notice of appeal, which must be served after filing under Rule 88, and then you have to serve it again within 14 days. Then 90, the respondent will just give us address. At Rule 91, you can also apply to strike out that notice of appeal. Maybe it was filed out of time. Rule 97 provides for the contents of the appeal. I believe my colleagues will go to details of this, because then those contents of the appeal is what creates the pleadings at the appellate division. The same to Rule 99, which provides that that record of appeal then has to be served within 7 days, followed by an affidavit of service. If you have to amend your record of appeal, that will become a pleading, and there's a format within which to do it. If you have to provide a supplementary record, that is a pleading. You'll have to do it in the proper format. But even the respondent, as you file an appeal against them, they have a right to file a cross appeal. The documents they'll prepare will also become a pleading of the courts. Once all documents have been served, filed and served, there is also a scheduling conference at the appellate division, which comes 14 days after the close of the proceedings. And it will also set out what has been agreed by both parties, including the length of hearing or any other matter that is deemed necessary. Rule 111 It is just the presentation of arguments in writing at the appellate division. So any documents which you are filing in courts, it forms part of pleadings and has to comply with the rules of the courts. I think I've covered sufficiently within the time the succinct features dealing with the pleadings of the courts. It is important, and I'll advise that you familiarize yourself with the new rules of procedure. They are not slightly off what you have always known. We just made them more user-friendly and aligned them properly to the procedures of the courts. Thank you.
Your Worship, thank you so much for brevity. Thank you for summarizing for us what the rules are in relation to the pleadings. I know there are questions that will still come, and we'll be attending to them. Ladies and gentlemen, again, I saw a number of you joined when we had kicked off. This is a master class on pleadings before the East African Court of Justice. The one who just left the stage is Honorable Yufnali Sokubo, the Registrar of EACJ, who was basically taking us briefly through what the current rules are as they relate to pleadings, what different pleadings are filed before the court, and what rules to be invoked in the process. May I now invite Mr. Justin Semuyaba. Mr. Semuyaba will be taking us through the nature and content of pleadings to be filed before the East African Court of Justice. Mr. Semuyaba, the floor is yours now. Thank you.
Thank you. Can you hear me?
Mr. Semuyaba, you are quite clear. We can hear you.
Okay. Thank you so much, everybody, for attending. I'm tasked to discuss the nature of pleadings in the East African Court of Justice. I'll talk about and use examples of some of the cases that I've handled before and the bottlenecks or problems faced in dealing with pleadings in the proceedings of the court. As the registrar has said, when someone is drafting pleadings for this court, he or she has to be careful about raising a cause of action. My first case ever to file in the court, I was pondering how to approach the court. How did I sort it out? As the registrar said, establishing a cause of action with the court can be learned by like this. The moment you look at the treaty or any other protocols made under the treaty or laws made under the treaty, and you find that there's any infringement of the treaty, that is when you establish a cause of action. So basically, a cause of action in the East African Court of Justice is simple and clear: infringement of the treaty and the interpretation of the treaty provisions or enforcement of treaty provisions. Those three catchwords can help somebody to always know what kind of pleadings go to court. The cause of action is very important because the moment you don't mention what provisions of the treaty of the law that are infringed, then the court won't be able to understand what kind of cause of action you are raising. Now, the famous case of Anyang Nyong is very instructive on this. It's the one that I've seen that has discussed this most. The court said that the cause of action in the East African Court of Justice is not the ordinary cause of action that we know in our courts, which is famous in the case of auto garage, where you establish a right, a breach of that right, and then damages. The cause of action in the East African Court of Justice is rather different. It is infringement or interpretation of the treaty or enforcement of any rights in the treaty. So the cause of action is very, very different from the cause of action that we know at common law. Now, when you have established a cause of action, that's when now you start drawing the papers or the pleadings, as the registrar said, and one has to be careful to mention the address, the subject matter of the reference, and the summary of points of law. Now here, when you're making the summary of points of law, the court normally requires you to specifically mention the particular provisions of the law that have been infringed. And then, as the registrar said, you have now to support your pleading with the nature of evidence. Now, the nature of evidence, there are some experiences of cases which people can look at where you may draft very good pleadings. You mentioned treaty violations, but then now when it comes to the trial, you fail to raise evidence. I've seen that happen in the famous walk to work case, where some people sued for the demonstrations that used to take place in the Kampala streets. When I read through that case, you can find that the lawyers worked so hard, they did everything, they drafted very nice pleadings. The court actually, in the judgment, said, yes, we have established that the provisions ABCD have been violated. But then when it came to the last question, then the judges now said, but what evidence has been put forward to show? Have you brought any witness of any person who was beaten on the streets to come and testify? Then at the end of the day, the judgment was lost because of lack of adducing of evidence. So somebody going to that court must be conscious of the fact, like in our ordinary courts, once you have pleaded, again, support your trial matter with cogent evidence, oral or affidavit. And the rules of evidence apply, primary or secondary evidence, and there are always objections to the nature of evidence that somebody is going to adduce. The other point that is very important for any practitioner who is to go to this court is to establish the legality of the personality who is going to court. Under Article 30, the court has on several occasions dismissed some cases where, for example, a person is not a resident of the East African community, or he hasn't established that he's a natural or legal person, and he has failed to show what kind of act or regulation or directive that he's challenging. The other always disturbing or challenging point for any practitioner going to this court is you must establish to this court that it has jurisdiction over the matter. Now, that one can be found in Articles 27 and 30 of the treaty. You are not going to find it in the rules of procedure, but you are going to find it in the treaty. Now, there you have to establish that you are raising a matter which falls within those provisions. This court has made precedents where it has defined its jurisdiction and divided it into like 3 categories. There's what they call rationale personnel. Under Article 31 of the EAC Treaty, any natural person or legal resident of the EAC may bring any case to the East African Community. Then the other leg is rationale temporis. Causes of action could fall within the temporal jurisdiction of the EACJ court if they have occurred subsequent to the EAC treaty coming into force. But one has to always have in mind that this court has a very strict rule of 2 months limitation that guides its exercise of jurisdiction. The court will refuse to exercise jurisdiction once your cause of action does not fall within the period of the 2 months as stipulated under Article 30. Then there is rationale material. Under Article 31 of the treaty authorizes legal and natural persons resident in the state parties to make a reference and file a case in the court. Now, the other taxing point in the nature of pleadings or cases filed in this court is the jurisdiction about human rights. This court has decided in many cases that the treaty was designed and in such a way that it excluded human rights matters, but several cases have come up to say that no, by the nature of Article 6D and 7.2 of the treaty, the jurisdiction of human rights is implied. Now, so that one has for now, I think, given a window for human rights matters to be filed in court. But of recent, the court, of course, has been receiving matters that do with infringement of the treaty, interpretation of the treaty, and maybe human rights. But ever since the Common Market Protocol came into place, the court now has opened up to trade and investment matters. So any serious litigation, litigant or litigation lawyer who wants to access this court has to go outside the treaty and look at other protocols that have been made. This court has decided that it has jurisdiction to handle trade-related matters. So the platform of the cases that the court receives has now expanded from mere human rights or interpretational issues or infringement issues to a wider base of trade and investment related issues. And of recent, many cases have now been filed relating to trade related issues. The court also has an easy, when you compare it to so many other international courts, this court, the admissibility issues are not so complicated. Comparably to the African Court of Human and People's Rights, the East African Court of Justice has no requirement for you to first exhaust local remedies. We experienced that in the case of Democratic Party versus Secretary General of the East African Community and the Attorney Generals of Uganda, Kenya, Rwanda, Burundi, where court held that this jurisdiction is not voluntary, and once an applicant can show an alleged violation of the treaty, the EACJ must exercise its jurisdiction without necessarily waiting for somebody to first exhaust any local remedies. And that case, plus a previous case of Plaxida Lugumba, has emphasized the jurisdiction of the court to interpret and apply the African Charter on Human and People's Rights. Now, when you go into the African Charter on Human and People's Rights, then there again you get a wide spectrum of issues or matters that you can get a cause of action or draft pleadings from. Because other than the treaty, under Article 6D, the East African Community is supposed to be governed in accordance with the good principles of good governance as stipulated under the African Charter. Now, the African Charter has so many issues that are wider than the treaty at times. And then it makes you have access to application of international conventions and other related treaties. So any serious practitioner trying to draft pleadings to the East African Court of Justice, it is advisable that you read carefully Article 6, 7, 27, and 30. Then you'll get a wide spectrum of matters that the court can accept. Articles 23, 27, and 30 are, to me, a must read for anybody trying to draw pleadings to this court, because they help you to structure your pleadings within the limits of the court. The land registrar has gone through several of the procedural issues. That what I've been talking about is applicable to filing pleadings in the first instance division. Now, the registrar has also talked about the fact that there is possibility of appealing. Now, he has shown you the rules of how to raise an appeal, filing a notice of appeal, a drafting an order, then memorandum of appeal. Me now, I will talk about what kind of appeal does the Appellate Division of the East African Court of Justice entertain. Now, anybody trying to appeal from a judgment of the court, first instance, once you have lost in the first instance court, you have to address your mind to Article 35A of the treaty and Rule 77 of the rules. Now, it's a must that if you are raising an appeal to the Appellate Division, that appeal must be based only on points of law, 1, grounds of lack of jurisdiction, 2, and procedural irregularity, 3. Several cases on appeal level have been lost at a preliminary point raised once the other lawyer raises an objection on your appeal that it is raising matters to do with evidence that are not necessary points of law, grounds of lack of jurisdiction, or procedural irregularity. Now, that has been a taxing point for legal practitioners who want to raise appeals in the Appellate Division of the East African Court of Justice. That appeal court never entertains appeals based on lack of evaluation of evidence. Actually, when you're drawing your memorandum of appeal and mention that the land judges add in law and fact, that one alone now puts you on a firing line from the respondent's lawyer, who will say the memorandum of appeal or the appeal raised is incompetent because it is raising issues to do with evidence, facts, and it's not within the limits of Article 35A and Rule 77. And many appeals, you'll have to read through the cases, have been lost on a technical point of raising grounds which are not based on law. So a practitioner raising an appeal to the Appellate Division must be careful when you're drawing your memorandum of appeal to that court, because the court will not allow you to go back into evidential issues. You will only have to go there and tell it there's a serious point of law that has not been considered, or there's some irregularity in the procedure which you must exhibit, and so that your appeal can be successful. The court also, there is a possibility of reviewing judgments. Now, there, the the provisions of review that we know in our ordinary courts, the requirements of a review are the same, that you must exhibit that there's discovery of some important fact or which might have had this decisive influence on the judgment, and if it had been known to the court, the judgment given would have been different, but that fact at the time was unknown to both the court and the parties making the application, and it could not, within reasonable diligence, have been discovered by the party before the judgment was made, or on account of some mistake, fraud, error, or on the face of the record, and some injustice has actually been done. So anybody who loses the case in that court may debate, and it's a serious decision you have to take, whether to review or appeal. The same way we make here a decision, should I review or appeal? When you have lost your case, you must know which route to take. And of course, when you take that, like they say, when you go into a roundabout, if you take the wrong road, it's up to you. So you have to carefully choose between reviewing or appealing, because both of them are available at the court, but they have different considerations. Now, the court, under the treaty, after giving judgment, has a challenge which all of us, of course, any practitioner now will meet. Maybe before I go there, it's good for practitioners now to know that the court has now opened the window for giving judgments that will eventually be able to allow people have remedies which are more than mere interpretation or declarations. Because recently in the Right Honorable Margaret Ziwa case, which you'll Google and search, in the Appellate Division, the court was able to decide that no, the court can be able to go and give more redress, more than just interpretation. So meaning that case opened way for other remedies that can be got from court. In other words, you can plead damages, you can plead special damages, general damages, exemplary damages, or any form of compensation. So now that one will mean that if you're drawing pleadings and you're claiming any kind of compensatory damages, the same rules of pleadings for damages will apply to you. For example, you are not going to ask for compensation when you have not pleaded particulars of special damages like we normally do in our pleadings here. If you are going to expect that court to give you special damages, you must plead them specifically and prove them specifically. If you are going to ask for general, exemplary, or other punitive damages, you must lay evidence upon which the court will assess the damages before they are granted. But now, of course, it is possible to get compensatory judgments. Now, if the court can give compensatory judgments, then now the challenge comes to execution. You have to know that after getting a judgment which is compensatory, you have to immediately go to Article 44 and Rule 74 and extract the relevant documents which can be able to be transferred to wherever you're going to execute. That court itself is not an execution court. So you have to transfer your orders to the partner state or the court, the local courts of where you are going to execute that order. So somebody has to look at Article 44 and Rule 74 of the rules, and you must get the registrar to get for you the papers to come and apply for execution in the local court. The court has got a website which has got cases. Anybody can access it. So what we may not be able in this few hours or hour to read and tell you every case, but when you go and try to read through the cases that have been decided in the court, then you'll be able to see how the court has interpreted the rules of pleadings, or how people have lost pleadings because of negligence. The common problems that come to litigants that I've seen, or new entrants in the litigation of that court, is to forget that that court has got a very strict limitation, strict and short limitation period of 2 months. The moment you don't plead in your pleadings that your action falls within a spell of 2 months before you commence your action, you are going certainly to land into problems, because those problems will be limitation as an objection. Then the jurisdictional issues will also start hovering around you. So anybody pleading or trying to take a case, please remember to look at the limitation of your action, because the court has, I remember East African Law Society tried as much as possible to tell the court that please interpret that provision in such a way that, for example, there are some actions which are continuous, but it's very, very difficult to circumvent that 2 month period limitation. I would like to thank you for organizing this session, and maybe before I leave, there are some things that have also always disturbed me. The way the nature of these pleadings, I mean, the rules are designed. For example, the registrar will help us and any other participants who may have a way out. The registrar talked about the filing of pleadings. Filing of pleadings have got timelines. Now, the moment I file my statement of reference, the other party is expected to file a response within 45 days. There's also a time limit within which to make a reply. But now the challenge comes, if somebody is late in filing, then I've totally failed to understand the rationale of this rule. You accept the pleading, though out of time, but you say lodged out of time. Now, the question that will always linger around as the case is going on, is that pleading going to be used in the trial or not? It's a stamped lodged out of time. Do you have still again to struggle to answer it? Because in our ordinary rule courts, normally when you are out of time, you have to apply for extension of time before your pleading is accepted. But this court accepts a document, it goes on the file. Somebody has not even accepted, applied for extension of time. What happens to that document? To me, the word lodged out of time has always bothered me. Why you the draftsmen of the rules have insisted that it stays. The ordinary rules in our courts are, if you are late, you are late. Somebody can get maybe an ex parte judgment, or if not, you come and plead and extend time and have your document accepted. Thank you. Yeah.
Thank you so much, Senior Mr. Semoyaba. I think you really raised the temperatures. You took it right from where the Honorable Registrar left on the rules, and you straight took us to the deep end. And I'm pleased that you did spare thoughts, especially on the very problematic areas. The one you've actually just concluded with, which is about lodging documents out of time. I think at the very tail end, the Honorable Registrar will be able to clarify the importance of that lodged out of time stamp and how you can go about that particular issue with the judges in the open court. I'm actually pleased with other areas that you have touched on, especially I believe our attendees and our members listening took key note of where you started, that one must identify the course of action by specifically invoking the relevant provision of the treaty and by informing the court that the court has jurisdiction and raising that jurisdiction appropriately. And you've also raised a very important issue about identifying the matter that is subject to challenge, not just talking about a breach of a treaty, but identifying the offending matter, be it a regulation, a directive, an action, and specifically bring it on board. And also intertwining evidence properly as you bring your pleadings, especially if you are relying on documentary evidence by way of affidavit. And it's important that you've also touched on appeal. More often when we do these trainings, we focus on the processes at the first instance division, and we rarely talk about appeal. I'm glad that you've touched on appeal and raised the important fact that appeals at the East African Court of Justice Appellate Division lies on points of law, not non-appraisal or wrong appraisal of evidence. Basically, facts are not to be considered at the Appellate Division. There are a number of questions that have come through. We'll be attending to them at the tail end. Ladies and gentlemen, allow me, even as I thank Mr. Semuyaba, to invite Faith Masharia. Faith, a partner at Ajarwala & Kana, specializing in commercial litigation and arbitration, and also well-seasoned and skilled on the process of the East African Court of Justice and disputes on the customs, union, and the common market protocol, to take us through the third level of this session, which is perfecting pleadings. Faith, please, the floor is yours.
Thank you, Mal. Just give me a moment to share my screen, and then we can take it up from there. Just 1 minute.
It's already shared. You can just put it on the presentation mode.
Okay, that's fine.
Thank you. We can see it.
Thank you. So good morning, ladies and gentlemen. It's a few minutes to noon. It's my pleasure to be here, and thank you so much, Hannington, for this opportunity. I think the previous speakers have done a good job. We've had a lot of practical tips from Mr. Semuyaba from his many years of experience before the East African Court of Justice, and his worship took his time and took us thoroughly through the relevant rules that we need to bear in mind when drafting pleadings. So my work will be quite simple. We'll just be looking at drafting of pleadings and the pitfalls so to avoid. So in this area, I'll just cover 3 points: the importance of good drafting, tips on good drafting, and finally, the pitfalls to avoid in drafting. Now, I know our focus today is drafting at the East African Court of Justice, but the tips that you're going to share today, they may be applicable or will be applicable, or you'll find them to be relevant and practical or useful for when it comes to pleading before other forums in your local jurisdictions or even before international forums like various international arbitration tribunals. Now, quickly going to the first slide. Now here I'll want an input from the participants and the panelists if they so wish. As we go through our discussion this morning, I want to have the audience views, okay? We've heard about the rules. Now, what do you think as the audience? Do you think the quality of writing or the quality of your pleadings, they matter as long as you've complied with the rules? His worship took us through the rules. You've complied with the rules. Do you think the quality of your pleadings matter? Do they have an impact, if any, to the outcome of the case? So you can use the chat buttons and let us have the views, and maybe our moderator can read some of the views at the end of this session. Now, I'll start with the importance of pleadings. Why did we take the time to discuss pleadings today? Now, in my view, this is the entrance point to the court. Remember, this is the first encounter. You're filing your pleadings even before you appear before the judge. And you want to tell the court the story. You want to tell the court your client's story. And clients want their stories to be told in a compelling way, compellingly. And when you draft your pleadings, you actually set the scene. If you're sorry, you're setting the scene of your case. And judges, when they look at your stories, Mr. Omuyaba will tell you that they develop first impressions, either good or bad, based on what they're seeing on the pleadings. And based on and this is actually based on the clarity which parties take their position. Now, remember, even before you appear before a judge, whether physically or virtually, as now is the new norm, the bench will have seen your pleadings already. And it is therefore important to make sure that your pleadings set the right tone and they set the right scene for your case. Now, don't forget that your adversary or your opponent, they're scoring your pleadings. We've been given examples by Mr. Semuyaba where pleadings have actually been struck out for failure to meet certain requirements under the rules, right? Some of these oversights, so your opponent will be scoring your pleadings. They're looking for fatal oversights, some of which may merit immediate dismissal and others may remain dormant until opportunities to correct them pass. So these are some of the key things why we need to be careful when you're drafting pleadings. Now, the other thing is, and this is actually, we've taken through the procedural part of it, and you're saying that the pleadings are important because, number one, they serve the procedural fairness, as been discussed by the previous two speakers, right? But also most importantly, it's because when you're talking about relevance of evidence, you're talking about admissibility of evidence at trial. This question will actually be decided by referring back to the pleadings. And in this respect, I actually say that pleadings are like pegs on which the evidence hangs. They're like pegs on which the evidence hangs. There have to be a relation between what you have pleaded and the evidence that you're adducing in support of your course of action or your case. Ultimately, remember, the trial judge will decide your client's case, okay, on the basis of evidence as it relates to the issues defined by the pleadings. There has to be a nexus, and I think we cannot overemphasize this enough. And Mr. Semuyaba talked about the trial conference under section 11 of the rules, the EACJ rules 2019. And this is actually where now the clarity of the pleadings is important. Is it that a case that the parties can go to mediation? And such clarity can only be easy to identify with, both to the court and to the registrar and to the parties, if the pleadings are properly articulated. So avoid confusion in your pleadings. Talk about efficiency, so to speak, right? You prevent unnecessary costs, just like we have been told, unnecessary costs that can arise. Maybe you want to amend your pleadings at a later stage. Of course, at times, as a practitioner for over a decade, at times, it is necessary that you amend your pleadings. But if you do the prerequisite steps that we're about to say, at times it may not be necessary to do so. Let amendments of pleading, so to speak, right? Failing to look at proper evidence at the time. These are some of the things that actually lengthen the time of the case and, do away with the efficiency. Suffice to mention, and I know most of the practitioners online will actually agree with me, that increasingly, our clients are becoming cost conscious. They're looking for effective way. They're looking for cost-effective means without compromising the quality of the work. And these are the things that we have to bear in mind when you're drafting pleadings. Now, the last thing and the important thing about the importance of pleadings, and I think this has also been touched upon, is to bear in mind that you are bound by your pleadings. That has been discussed, and I don't intend to dwell on that. Now, I'll quickly go to the tips on good drafting. Now, we've heard about choosing the right course of action. We cannot overemphasize enough, especially for this forum, because there's choices of actions in the East African Court of Justice. They're specifically pleaded in the treaty. You have to look at Article 30 of the treaty and ask yourself, what I have pleaded, the course of action, does it give me access to the court? Does the court have jurisdiction over the course of action that are pleaded? For example, maybe you've pleaded infringement of the treaty, enforcement of the treaty, right? So those are the things that you need to talk about. Maybe you're asking, how do I choose a right of the course of action? Now, this is a very obvious and a fundamental point about pleading. And you need to first analyze both facts of your case and the law. There's no point, honestly, embarking upon to plead without having a close analysis of your facts, of course, within the time that is permitted. So you have to identify your cause or causes of actions. It could be many, right? The action you rely upon, and most importantly, what are the elements, so to speak, of these causes of action, right? And do you have evidence, so to speak, to prove those causes of actions? Now, closely intertwined to this point is material facts. And I know a question can be raised. What are these material facts? Now, for you to answer this question, you need to know what are the elements of the cause of actions. That is actually what will form material facts, or what is necessary for you to plead. Now, the next tip that I'll actually share is that your pleadings need to be clear, and you need to plead the issues separately, right? In separate paragraphs. You need to have a step-by-step approach. You can list your issues, of course, at the beginning, then come up in a way to deal with the issues step by step without merging them unnecessarily. That can easily create confusion. And we have a specific rule under Part 4 of the rules of the East African Community Court of Justice Procedure Rules 2019, which specifically requires that every pleading shall be divided into paragraphs, numbered consecutively. So take advantage of that. Let each issue be addressed in a separate paragraph. Equally, there is nothing in the rules about headings and subdivisions, yeah? But it is generally acceptable in this court, as well as in other forums that we have appeared before, that these are useful tips, or they're useful ways of adding clarity to longer pleadings. So you can use headings, for example, specific damages, you can make that as a heading, and you can use subheadings with that. It's just having creative way of making your pleadings clear and separating the issues. Now, the other point that I call ATS just means end of trial submissions. So when you're thinking about your pleadings, have the final goal in mind. Otherwise, you'll be shooting in the dark, right? So at the beginning, shortly after interviewing your client, you need to draw up end of trial submissions, right? Of course, I know at that time, maybe you're thinking, oh, I haven't gone through the evidence. It may not be perfect. That is okay. But it will give you a helicopter view of the case that you have to meet, right? And to actually tell you which laws, for example, that you should be looking at. It's not appropriate for you to be scrambling at the last minute to draft submissions as you realize that the evidence and the law that you've actually recited does not support your case. This is something that you can avoid by preparing end of trial submissions at the start of the process. Now, dealing with missing evidence. Mr. Semiyaba has given us a case, a real case that was actually dismissed, a very good case, properly pleaded by the lawyer, properly articulated before the judge, but it didn't have evidence in support of it, and the case was thrown out. Now, how do you deal with missing evidence at the beginning? You need to first identify and hunt down missing evidence and witnesses at the beginning. You need to determine who is going to be the source of the missing evidence. You need to determine whether it will be disclosed maybe through the discovery process. Will the evidence be disclosed by calling a witness, for example? And if so, you need to identify these witnesses as early as possible. And of course, remembering the rules of evidence that you've been reminded, they still apply. The rules of production, primary evidence and secondary evidence. Now, if you need a document, just hunt it down. Do not hope, right, that you'll be able to draw missing information through cross-examination or from the other party. I mean, you cannot get what you do not know exists at the first instance. Now, we look at the relief sought, right? I mean, often it actually pays to consider the relief you wish to obtain before you commence the pleading at all. so that you need to know whether the preconditions for grant of such a relief have been taught. And also thinking about the relief at the very beginning, it will guide you then to the facts that must be pleaded and proved to make the available course of actions or actions. Now, let me give an example. If the relief that is required by your client, right, is the performance of a particular contract and not damages, because you really have to be very clear what sort of relief your client wants and what can be given by the court. So you have instructions and the client is looking to get an order of specific performance and not damages. Then, as a matter of necessity, specific performance must be a course of action, or one of them, so to speak. So you have to think about this at the drafting of your pleadings. Are you seeking a declaration? Are you seeking an order of permanent injunction against the state or a state party? But most of all, you need to formulate your course of action. Don't leave it to the court, right? And quickly, I've just come up with a checklist. Of course, this is not a conclusive checklist, but it's something that you can continue developing. It is a useful tool when you've actually drafted your pleadings, and quickly before filing your pleadings, just to have a look quickly, yeah? Of course, if you're experienced with years of experience, this will come automatically. But as you're developing experience before this court, it may be helpful to have a checklist. It may be helpful to have a checklist for your junior lawyers as well in the office to quickly check through whether they have met these things. Number one could be limitation period. We've spoken about the strict limitation periods before the East African Court of Justice. 60 days or 2 months, as you know. Or 2 months. And we've seen the possible consequence that were highlighted by His Worship for failure to file your claim within the time period. Look at the course of action. The course of action in the East African Court of Justice is also very specifically provided for in the treaty. So whatever you're pleading, is it a course of action that falls within the jurisdiction of the East African Court of Justice? Have you been brief? Have you been concise as the case permits? Have you included all material facts? Remember, we've actually looked just in the preceding slides what material facts are. So have you included all material facts on the claim, right? Then you need to specifically plead any matter required to be pleaded. You are given an example of specific damages. So you need to make sure that you've actually pleaded that. Have you set out the relief? Have you set out the statutory provisions? Remember, this is, again, it's important that the East African Court of Justice, you have to specifically set out if it's an infringement of the treaty, it's an infringement of the protocols, the infringement of the regulations. You have to specifically set out. So make sure that has been done. Have you given sufficient information, so to speak, for the respondent of the defendant to be able to respond to the claim? And if required, because it's not all instances as highlighted by His Worship, has the party sworn an affidavit in the pleadings? As I say, this is not a conclusive list, but it's a good starting off point, and you can make the checklist as useful or as long as is necessary, just to make sure that you're not falling into the pitfalls when you're filing proceedings before the East African Court of Justice. Now, having looked at what can help us come up with good pleadings, now, what are the things or the pitfalls that we need to deny, to avoid? Remember, as I said, these arguments or these points or these tips, they're applicable to the East African Court of Justice, and they could be helpful in any other, forum that you find yourself, representing your client or appearing before as an advocate. Now, I think the first one that actually came to my mind almost automatically is bare denials. Bare denials. It's not unusual. In fact, I might say it's usual in everyday, in our practice that we're seeing bare denials in our pleadings. This is an example. Paragraph X of the plaint, memorandum of claim, or the reference is denied, and the plaintiff is put to strict proof thereof. Honestly, the phrase is put to strict proof thereof add absolutely no value, in my view. I know we do it because maybe we found our mentors doing it, or our people masters whom we generally look up to, and there's nothing wrong with that. But do we even pause for a moment to interrogate some of the statements that we use in our pleadings, right? Now, even if you say that the plaintiff is put to strict proof, and the plaintiff, they prove their case on a prima facie, right? And their story appears reasonable to the judge, you're dead in the water. You have no alternative story, right? So what you're saying is, always plan or always endeavor to have an alternative story, have an alternative hypothesis, have an alternative argument to rebut their verment and bolster your position. This will stop the judge at the very beginning from migrating to the plaintiff, as opposed to when you've said, this is put to strict proof thereof. But when you have an alternative argument, it actually, just stops that instantaneous move of the judge, or the judges, the bench as it may, to the plaintiff's side. Now we can look at an example. Now, you can have an example maybe saying, paragraph 7 of the plaintiff's statement of claim is denied. Then you can go ahead maybe and say, although a contract was formed, maybe they were saying a contract was formed, it is actually true the contract has formed. It could be true or it could not be true. So your response, instead of saying the contract was not formed and the plaintiff is put to strict proof thereof, you can think about saying, the statement of claim is denied, then have an alternative hypothesis, which could be, although a contract was formed, it became illegal by the passing maybe of a new act, right? Then the judge, on her part or his part, will have his eyes fixed on the effect of the illegality point, even before she addresses herself to the plaintiff, point whether there was a contract or not, or the legality point, before she addresses a man to the plaintiff's lack of mitigation of loss, if at all that is something to have been pleaded. Now, the second point that you need to avoid is pleading blindly. Let it also take it practically. How do you plead a case? Maybe this is how you've done it in the past. The first thing you did is you met your client and you took instructions. Very well. Then after that, you went into precedents. Maybe precedents that have been drafted, they're in your precedents, data. If you have in my view, in my experience, this is not a good approach. If you plead your case on what your client tells you without independently verifying your facts, I can say that you're pleading blindly. And you don't want to discover some pleaded facts to be untrue, or the evidence for them cannot be obtained when it is too late. And then now maybe you consider amending or not. Amending your pleadings, or worse still, it can even become embarrassing to the advocate in court, just like the example that Mr. Semuyaba gave us. So it's actually good to independently identify the client's instructions. How do you do that? You look at the instructions the client has given and look at the evidence that the client has given. Are they adding up? Are they marrying? Are there gaps before you even start to draft? If there are gaps, this is a good opportunity then to go back to the client, right? And clarify those gaps. Clarify those gaps at that time. Of course, time permitting. Otherwise, if you don't do that, and I've actually seen this practically, you'll be compelled to force fit. You're force fitting your evidence to your pleadings. And this is something that you don't want to be happening to you. Now, the other thing, and I think this was touched by His Worship, do not plead arguments, plead evidence. I mean, that's actually quite self-explanatory on the face of it. And we actually gave an example of a court of appeal decision from, the Supreme Court decision from Uganda, where they were just saying you don't need to plead your evidence in pleadings because they are necessary and they're superfluous. So you just need to confine yourself to pleading the facts, confine yourself to pleading the arguments and not to pleading the evidence. Now, another point is leaving matters as a surprise, right? Mr. Semuyaba will tell you, and many others have been there for a while, that litigation is not a game of cards. It is not a game of cards. You cannot be waiting to say you will release these facts at a later stage. You need to plead all the issues. Remember, you have said that you actually bound by your pleadings. So you need to plead all issues relevant to the claim. Do not hold back issues or matters in your knowledge that they'll be brought up at a later stage. And we know this is a common law jurisdiction, especially most of us, apart from, of course, our brothers from Burundi, and that this may amount to ambush, and you run a risk of the court not permitting the matter to come relied upon, because parties again are bound by your pleading. So don't leave matters as a surprise. Plead your case, put it forth clearly and concisely. Now, other things that we've actually seen is lengthy pleadings, I mean, paragraphs. You can actually get a page, maybe you have 2 paragraphs, right? I mean, we actually, my proposal, I'm actually of the school of thought that if you use shorter and sharper paragraphs when pleading, it makes it easier for both the court to understand the issues and to find the relevant facts necessary to establish the claim. Remember, our courts actually, overwhelmed with work, right? And you want to present your client's case the best way possible. So make it easier. Help the judges understand your case, and you can do so by proper pleading, use of shorter and sharper paragraphs, so to speak. Now, the last pitfall that we find ourselves is admitting allegations that are not pleaded. I know you're saying, how can I admit something that is not pleaded? It's not obvious. Let's look at an example, right? Now, the plaintiff may plead in a local jurisdictions, right? May plead in a medical negligence case that the plaintiff is a doctor, or the plaintiff is a doctor. They can actually say that he was a doctor. The doctor was a member of the East African School of Medicine, for example, right? Now, the fact of the matter is that the doctor is a fellow of the school and not a member. Now you get a defendant saying, the defendant admits that he was a fellow of the school. That is not what is pleaded against you, right? Okay, was a fellow. So also, remember, I've actually used the term at all material times. Sorry, to actually be reading at all material times as opposed to all material facts, right? And we've actually seen use of this. It's almost normal in our pleadings. But I'll be a bit cautious when I'm using these words at all material times, because it can create an extra and unnecessary burden of proof on your client. So be careful not to overuse it. It is acceptable, honestly, to plead the expression at the commencement of a pleading. For example, you can say, at all material times, the defendant was a duly incorporated company. But be careful in this example, maybe you're pleading later and you're saying, at all material times, the defendant was engaged in trade or commerce. When there may be a number of times material to the action, you only need to prove that the company was engaged at the time of the relevant representation. So you have to stick your facts, your pleading, to what is relevant to the course of action. So we need to be careful again with the terms that we use. And having said that, I think in a summary, what I can say is simplicity is key. Simplicity is key in our drafting. Thank you so much, Amol.
Thank you so much, Faith. I think you've actually thrust us into, the technicalities, the technicals, and the common mistakes we go through in our day-to-day drafting, not just for the EACJ, but even for our other litigation matters. And I think that's quite welcome. And I believe I've seen a lot of comments coming through, especially on the points you ask, and indeed, properly pleading them. So now I would request us to straight away attend to the comments and the questions that are already coming through. Others have already been addressed by the registrar on the chat, but for good order, we will go through them. The first question is coming from Sarah Njuguna, and she's basically asking the question about residency that has always been problematic. Are we talking about citizenship, or are we talking about residence? And what does it mean to be an EAC resident? Does it mean you have to be staying physically within the EAC? What would happen if you are temporarily out of EAC, you've traveled and probably on study or something like that? Do you still remain a citizen for the purposes of bringing a claim before the East African Court of Justice? And I believe this would be addressed by the registrar, but both Faith and Justin could also take it. As you address that, I would want you to consider when determining the issue of the residency, what time do we look at it from? Is it at the time that the matter is being filed, or at the time that the cause of action arose? You know, if I was resident in EAC 2 months ago when a violation occurred against me, and I've since lost that residency, probably one of the issues I'm raising is even the loss of residency itself. We are looking at extradition or this loss of investment, loss of investments where governments nationalize investments, as we've seen in the cases of Rwanda and Burundi, in some cases that are already before the EACJ. Will such a person who has already been deprived of his investment and sent out of the country and denied residency be entitled to bring a claim at that point? So I think we can have that taken in as I take other questions. Registrar can start us off.
Yes, thank you, Huntington. First of all, this issue of residency, when it was deliberated at the Court of Appeal, there was a dissenting judgment of 3 against 2. That means it is still open to further challenge and further debate. There was no unanimity in that judgment. But residency, I think, comes in at the time of the cause of action, not at the time where you may be, because the treaty says any resident of the community can bring an action. I'll suppose if you're already out of the jurisdiction of EAC, then it may be difficult, or it is on very rare occasion that something will happen that will affect you, that make you file a case. Now, reading the provision of the treaty, it talks about a resident, not a citizen. And as I was answering online, you'll find a Chinese, so long as he's in the country legally. If anything is done that affects him and is not within the borders of East Africa legally, then he is competent to file a suit. This case where we had a dissenting judgment, and this is why I said it is something which we can still write about. This is a person who had property in Burundi and still has properties up to now. But he migrated and lives in America. And in his pleadings, what I think also created a problem, he said he is a resident of America. So people are saying, but if he says in his affidavit he's a resident of America, is he competent to bring a suit? Yet the treaty says a resident of East Africa. So it's debatable. You have property in East Africa, but you don't live there. Do you have a cause of action or not? I wish we have more cases so that one of these days we have a full bench coming up with a uniform answer. So it is something that is debatable. Thank you.
Thank you so much, Honorable Registrar. Probably Faith and Samuyaba, you can take 1 minute to go at that particular matter as we go into the next question. Samuyaba?
About residence, I've read the Burundian case. I may not remember it offhand, but it's one of the recent Burundi judgments, because one of the issues of residence that normally arise affect the people of Burundi and Tanzania, as you said, who have been deprived of property, who have run out of their country, but are desirous to sue or have got have filed suits or filed references in the EACJ. Now to them, the question of residence start arising. For example, he has gone to America and he has a case, or he has an ongoing case. That judgment which I saw of the first instance division, and it's most recent, the court was faced with such a scenario. The deponent of the affidavit deponed that the witness was at the time staying in America. And now, by the way, it can happen to any of us. Because of the COVID situation, you are locked up in Geneva. Your case is coming. Now, when you send an affidavit, the question is going to be, you are not in East Africa. So I think at this juncture, the question of residences, we have to address it in a very, very critical and analytic kind of way. What the court said, the deponent of the affidavit lost the affidavit and it was expunged. For a simple reason, the court said, at least if the deponent had deponed that at the time the incident happened, he was residing in East Africa, but now has gone to America, that affidavit would stand. So as the registrar said, residence is rarely considered at the time the cause of action arises. If at the time the infringement or the action that you're complaining about happened to you, you must have been staying in East Africa. I think that one is standard. But now the other issues that arise in definition of residence come, for example, with companies. Companies, even if they're foreign or local, at least companies, you must show that it is registered in East Africa. Then, as the registrar said, when they talk about residence, it doesn't necessarily mean citizenship. So anybody staying within East Africa can overcome that challenge of residence. Now, really, as the topic today is drafting of pleadings, meaning if you are going to face the challenge of the requirement of being resident in East Africa, now any draftsman of pleadings in East Africa, in the East African Court of Justice, must be careful to plead that my client, though now resident in South Africa, was at the time resident maybe in Burundi or Jumbura, but has, because of maybe COVID, been locked down in South Africa, which can happen to anybody now. So now the drafting of your pleadings will determine, because the case I've talked about, the court caution said, we would have saved this affidavit had the counsel pleaded that at the time the incident he's complaining about happened, he was residing in East Africa. The counsel was negligent and just said, I'm residing in USA, I'm saying this, and forgot to put a clause that that person ever stayed in East Africa. So it's important in drafting of pleadings to think of that, because it causes the case to be dismissed as a technical point.
Thank you. Thank you so much, Mr. Semuyaba. Faith, any go at 1 minute, then we can go to the next question.
Sure, thanks. I will want to agree with Honorable Pubol and Mr. Semuyaba that they'll actually look at the cause when the cause of action arose. And this, we cannot overemphasize enough the importance of pleading. Now, I also want to point out that within for a party, they need to be a resident in one of the partner states, right? So if you come back in Kenya, we actually have laws that actually define who is a resident in Kenya. And maybe I believe in Uganda, Tanzania, they actually have laws that define who a resident is in Kenya. So if you want to establish a resident, it could be maybe necessary to go back and see, do they qualify? Maybe at that level, maybe they're seen to just have gone to America. But maybe the fact that you've just gone to America for 6 months, it does not take away the fact that you are a resident of that country. If you look at the local definition of residence and you're able to justify that they are a resident in one of the partner states, then they do qualify. So it's also important also to see where there could be a nexus between the local legislations and how they could be relevant in making some of these justifications that are very necessary. Capacity, locus standi of a party to sue.
Thank you. Thank you so much, Faith. And there are many questions here, but let me go to one disturbing one, which is on the 60 days rule. And the case that was referred to earlier was the one filed by the East African Law Society, where I'm proudly a member, serves the Secretariat, where we were basically asking the court to interpret what the 60 days rule means. And if I could observe, as I ask my speakers to chip in, the 60 days rule was an introduction as one of the early amendments to the treaty, and it was one of the consequences of the Professor Nyang' Nyong'o case. So for those who are just interacting with the East African Court of Justice at this stage, Professor Nyang' Nyong'o case is a classical reading, and it basically summarizes the history of this court. And the registrar probably, I would invite him to give us, as he addresses the 60 days rule, give us briefly the history of that case, why the 60 days rule was introduced, because two questions have been asked here. Whether there's an exception to that rule, I believe there's none, but the speakers will get a chance to speak about that. But then the other question is, somebody saying, if I have a client who was detained 30 years ago, he still is in detention, when can, and that detention is unjustified, basically, the client believes that that is in breach of the African Charter and the court has jurisdiction under Article 6D. Now the question is, when did 60 days start to count? Is it at the time 30 years ago when he was detained, or at this stage when the detention still continues? And I believe the question of continued violation, as had been ventilated by the East African Law Society in that case, comes into mind. So again, once again, may I invite the registrant in that order? We can have 2 minutes each so that we have time to address the other questions. Thank you.
Yes, thank you, Hannington. Yes, the issue of continuing breach, as you say, it had been ventilated. Apparently, the court's decision was that it starts counting from the first day of the detention. Otherwise, then cases will come after 30 days, after 50 days, after 2 years, after 3 years, after 5 years. The court did not agree with the argument of continuous breach, which personally, I think that's the way they should have gone. Now the 60 days, the introduction of 60 days in the treaty was not a legal reasoning. Even at national level, we don't have 60 days limitation period against the state. We have 1 year. Now this was created out of anger because heads of states were not amused that they have come all the way for a meeting in Arusha and the court has stopped them from discussing their agenda. Just a day before the meeting, there was a court order stopping the heads of state from swearing in EALA members. So they were not happy about it. And they asked many questions. One of the questions they asked is that now you are saying we should not, EALA members should not be sworn in because the elections in Kenya were not properly done. When were these elections done? And they were told elections like happened in April and the swearing in was in November. So they were saying, but if these things happened in April, why are we being stopped now? Why has it taken so long? Why did they take so long to come to meeting is tomorrow? So out of that, the heads of state instructed the AGs to go and amend the treaty to make sure if you sit on your rights after 60 days, you will not be able to access the court. That is how the 60 days was brought in. It is part of our recommendations in the proposals to amend the treaty. It is unreasonable. That one I accept. And as I've told you, it was out of emotions. It was created out of emotions, not really out of legal reasoning. So I believe with the time, once the amendments of the treaty come, it is something that will be addressed. Thank you.
Mr. Samoyaba, please have your 2 minutes.
On this point, of course, it is a point which East African Law Society fought and filed like around 2 or 3 cases, but all of them were not successful. The court said until the treaty is amended, the court is unable to interpret it otherwise. But the practitioners can take maybe benefit of the drafting of the clause. The clause reads, the proceedings provided for in this article shall be instituted within 2 months of the enactment, publication, directive, decision, or action complained of. All, and I emphasize here, in the absence thereof, of the day in which it came to the knowledge of the complainant, as the case may be. Now, somebody can smartly run out of the 60 days and say, oh, I only got to know yesterday that you know, there's an infringement over which I can sue. And for me, surely, this, in the absence thereof, the day on which it came to the knowledge of the complainant, can be argued smartly by, if you coach it very smartly, you can use that window. Because, to be sincere, the matters to do with treaty infringement, violation, or need for interpretation are known by very, very few people. Even among staff lawyers, you make a survey in your jurisdiction and ask people about East African Court of Justice. Even the lawyers don't know yet that it is there. Now, how do you expect the ordinary citizen, the man on the street, the man in the village, to know that there is a treaty, there's an access to file a case in East African Court of Justice? So that person will come can successfully come out and say, oh, I only got to know when I saw on the radio that there's East African Court of Justice. So he can use that leg or some other way of, maybe you didn't know a certain document was out and you only got to know about it yesterday. So there's a window which can be used to run away. But otherwise, as the registrar has said, and anybody else will know, and the courts have said, the rule is interpreted strictly, and there's even, I think the court even went as far as saying there can even be no extension of time because it is a treaty matter. And they use this principle of you could extend time if the rule, if the provision was in the rules of procedure. But once it is in the treaty or a statute, until it is amended, you cannot even extend the time. That's the unfortunate bit about it.
Thank you so much. Thank you so much, Justin. Faith, a minute. I still have about 3 questions that I want to pose to our speakers within the next 10 minutes as we head towards the wrap-up.
Yeah, I think His Worship and Mr. Sebuyaba have actually exhausted that point. And I think just the way we are saying, there was no legal rationale behind that. It's more of a political position that unfortunately we find ourselves into. And I think a remedy could be maybe in amending the provision as it is. Now, how can parties take advantage of what we have? If you look at the second option that Mr. Semuyaba has said, it actually talks about 2 months from when you became aware, or remember, from when you became, or it came to your knowledge. But then again, in such a question, I think the practical question will be, then at what point did you become aware? At what point were you reasonably expected to have been aware of the course of action?
Thank you. Thank you so much, Faith. Now, I'll disrupt the order a bit and pose specific questions to each one of you. So, Your Worship, there's the question about evidence, and I'm sorry to ask you this, but I think you are the right person I could pose this to. Emilio Siemo is asking about circumstances under which one can rely on newspaper, cuttings and newspaper reports when the documentary evidence required is within the exclusive possession of governmental institutions and they are not willing to part with it. Will the court tolerate this in proceedings before, or will it be looked at as basically some loose kind of evidence. So the registrar can take that as I pose the next question to Mr. Semuyaba.
Thank you, Huntington. I think that is governed by the law of evidence. If it is the adverse party that has the documents I want and they are refusing to release them to me, and I can demonstrate to the court, I have sought these documents from them, and they are hiding them from me deliberately to defeat my case, and this is the only other source of information that I have. I think if you can lay a foundation for that, following the evidence, the rules of evidence, I'm sure the court can accept. But I think if we just bring up with a newspaper and say, this is what I'm relying on, without bringing the author of that story in that newspaper or the editor-in-chief of that paper to come and say where you got that story, it may not be acceptable. So it depends. These are matters of evidentiary value. It all depends on how the evidence is being presented and in line with the rules of evidence. Thank you.
Thank you so much, Your Worship. Mr. Semuyaba, and just on that point, Your Worship, I think we probably at our next training might want to talk about adverse inference, which is a point we recently tried hammering before the first instance. We are still waiting to see how that will go. Indeed, Emily, we were also in such situation by East African Law Society where the governments were holding on to crucial documentary evidence and they're not willing to release them. So we will see how the court decides on that particular matter. Mr. Semuyaba, Nsabimana had raised a question which the registrar answered on the chat, but you can take a minute to just clarify it, that where there are concurrent jurisdiction, basically the national domestic courts have jurisdiction over matter, and the EACJ also has jurisdiction over it. Will EACJ direct that the proceedings before it be delayed until the domestic matter is determined? I think it goes back to the matter of exhaustion of local remedies or concurrent jurisdiction. Probably you can just take, registrars already clarified it, but you can just take a minute or two as a practitioner and out of experience to share how you deal with such a situation.
Thank you.
Thank you.
Thank you, Mr. Moore. Before I answer that, let me just share a little bit of experience of adducing evidence we had in the Margaret Ziwa case. We had a challenge of the assembly has privileges where you don't just get their documents to be adduced in court by any member without the leave of the assembly. Practically what we did is to apply to court under the rules of the court can summon any witness. Equally, you can, and the court allowed and called the clerk to adduce documents. So the ordinary rules that we normally use in our courts of interrogatories, notes of production of evidence can be played around, and you fish evidence from the other side. To answer the question which have been posed to me, the question of jurisdiction, East African Court of Justice and national courts has been settled very well by a case called Charuhendwa. It was a legal opinion raised actually from the national court in Uganda to the, as you know, the case stated route of going to the court, which we haven't talked about here now, but it is an example of a case referred to the East African Court of Justice by a national court. In the legal opinion given, advisory opinion given by the Appellate division, which is the one with the jurisdiction to make advisory opinions, it at very great length or detail laid the parameters of the East African Court of Justice vis-a-vis the national court. And my understanding of that case is that the national courts have capacity or jurisdiction to apply the treaty or any other laws of the East African community. Meaning, if they are deciding a case here in the national court, they can quote the treaty and and apply it to the facts. But when it comes to interpretation of the treaty, the only court that has that, or the court that has the final decision-making capacity is the East African Court of Justice. So, to me, you have to convince the court that the point I'm bringing to you is interpretation of the treaty vis-a-vis a certain set of facts. Now, of course, you will meet an objection from the respondents, who are normally the attorney generals of the various partner states or the secretary general of the community, because they are the only respondents that can be sued in that court. But you have to be smart in your argument or your pleading to say that, well, I want the court to look at articles A, B, C, D, articles 20, 35, articles 40, articles 50, and there argue and convince the court that, you see, this is the only court which can interpret the treaty. So I've read decisions, and there are many surrounding that area. But when you analyze them all, you'll find out that they will tell you that if your cause of action is to interpret the treaty, then they have the jurisdiction. And the issue of jurisdiction of the East African Court of Justice has been handled. If you read a series of cases, you'll find out that it has been handled in such a way. One time I was having a chat with a very senior judge, whom I won't mention because it's for professional ethics. He told me, but you lawyers are very funny. You come to us, then you stand up, you start challenging us not to have jurisdiction. Now, right from the word go, the moment you raise the point that the judges don't have jurisdiction, what runs into their mind, he said, what runs into our mind as judges is that, you mean we can't even decide whether we have jurisdiction? Don't tell us that we are seated here and we can't decide. So normally the objections about jurisdiction, most of them I've seen, have failed. Simply because the court will clearly tell you that under Article 6D or 7, we have we can look at matters of good governance and all that. Article 23 and 27. So it will take a very big stretch of argument for somebody to convince the East African Court of Justice that if I'm suing about treaty infringement or interpretation of the treaty, the East African Court of Justice has lesser jurisdiction than the national court. In fact, it doesn't have. There is a specific provision in the treaty about that, when what is the role of national courts and what is the extent to which the East African Court of Justice goes. To understand that well, somebody has to look at Article 23, 27, 30, and specifically Article 33 is very clear. Except where jurisdiction is conferred on the court by this treaty, disputes to which the community is party shall not on that ground alone be excluded from jurisdiction of national courts. That means, yes, national courts can handle some matters, but decisions on the interpretation and application of the treaty, the court, the East African Court of Justice, takes precedence over decisions of national courts. So meaning, generally, the East African Court of Justice is far above the national courts in terms of treaty matters. Even then,
Mr. Samueba, may I interrupt you because we are almost hitting the time, and there are two more questions which I think would be pertinent to be addressed.
Yes, thank you.
Thank you so much. Now, Faith, I want you to think of this so that you can address Mr. Wani Santino, one of the icons of the East African Court of Justice, having challenged nomination of IALA members by South Sudan. If you've read of the Wani Santino Jada case, is asking or expressing concerns regarding the delay in hearing certificates of agencies. I believe you've also had a similar experience. Probably you will share how you've navigated this. Then I want the three of you to address the repeated concern about execution of decisions of the court. Are they respected? Are they executed? And have national courts generally been willing and ready to execute these decisions? And where they fail, is there a room for holding, somebody in contempt at the East African Court of Justice? I believe the three of you would be able to take this. Allow me to exit and invite my colleague, David Sigano, to take us through the remaining portion of this particular meeting. Faith, you can have the floor, then the registrar, Mr. Samueba, will follow you.
Sure. About the certificate of agencies and the delays at the East African Court of Justice, I want to say that I've been a victim of this process. We did file a certificate of urgency last year, December, and another one this year, and it took a while before the court responded to us in one of them, right? And the other one, we are yet to get a response. And I know these are questions that we've raised before in a couple of seminars, and we hope that that is something to be addressed. Now, what can you do? What some of the practical things maybe that you can do? Now, in one of the matters that it's actually scheduled up for hearing on 1st of September, what we did is that we wrote a follow-up letter. We did write a follow-up letter. Of course, we filed our certificate of urgency. And then now when we realized we're not getting a feedback, we wrote a letter to the registrar, and the office responded expeditiously together with the judges. And now we've been given a date on 1st of September. So one of the things that you can do is not just to sit back and wait for the communication. At times it's prudent to follow up with the court. It can be a way of a letter just to follow up and just find out what is happening. You also need to bear in mind the sitting schedule of the court, but that is something maybe His Worship can enlighten us more. Now, quick practical questions about other things that have been raised. On the issue of jurisdiction that Mr. Semuyaba was explaining, it is true that the East African Court of Justice decisions on the interpretation of treaty, they take precedence over national courts. So even practically in some of our matters, what we have done, if you're arguing a matter in a national court, then you come across an issue that squarely, honestly, should fall within the jurisdiction of the East African Court of Justice. We have stayed the matter in the local courts, then gone to the East African Court of Justice for determination of that issues. And I found the courts in Kenya being cooperative in that respect. Now, on quickly, again, my comments as a practitioner before this court on the newspaper cuttings, or the newspaper evidence. Now, you will note that the evidence that you're supposed to produce before the East African Court of Justice is supposed to be certified true copies of the originals. So it actually means that you need to have the originals, then make a certified copy for you to produce that evidence in court. Now, maybe you don't have a certified copy of the newspaper, or the original is with the government, or the partner states is most of the time the respondent. Then what you can actually do is the rules of evidence that apply in a local jurisdiction that also apply, as you've said, in the East African Court of Justice. Those are some of the instances that you can move the court for production of secondary evidence. Now, what if you're talking about a newspaper article that then makes reference to something else that only your opponent has? Now, there are instances when we move the court to draw certain inferences, especially maybe where you have served the AG with a notice to produce documents, or you've asked for the production of the documents, and there are no proper reasons that have been advanced why they cannot produce that document, then that is an appropriate time for you to move the court to make certain inferences out of the failure to produce that document. I think now I'll also give the opportunity to the His Worship can comment on the execution. Yeah.
Yes, to comment on the issue of execution and on the issue of certificate of urgency.
Yes, thank you. Every time I appear here, these two questions always come up. That is a pointer that they need to be addressed, maybe through another forum, to be taken forward to be addressed. Now, the issue of certificates, the rules provide for certificate of urgency, and I understand your frustrations when you file matters under certificates and they are not being heard. This is a structural issue that we are trying to address. As you know, not all judges are residents in Arusha. These judges also have work elsewhere. They come after 2 months. So you can imagine if 20 or more certificates are filed during that period and they come, it's not possible they can deal with all of them. Secondly, I am having serious human resource gaps in terms of the judges. For example, in the first instance division, instead of 6 judges, I have only 4. And you know, a quorum is 3. If I had 6, I would have been able to convene 2 sessions at the same time. 3 judges one side, 3 judges the other side, and these matters are hard. In the appellate division, instead of 5 judges, I have only 3. Because the others retired, they finished their term, they are yet to be appointed. Now the minimum quorum again is 3. If one judge of the appellate division was to be sick during a session, we can't move, and that will create a problem. So it is something we are trying to address. We have on several occasions discussed with our Council of Ministers to make the court a permanent court, where we'll have judges sitting in Arusha permanently. In that case, I'm sure you'll all love it if it was to come through, that you'll be able to file your certificate today and be heard even on the same day because the judges are there. There'll be no excuse of you telling you, wait until the judges come. So it is being addressed. I am hopeful with all the efforts we are putting that they will agree to judges being permanent in Arusha. Now the other issue again, which keeps coming up, and again, which is a pointer that something needs to be done, is the issue of execution. And as I said here earlier, there is no international court that has its own execution mechanism, including ICC. But that does not mean we cannot do anything. In fact, the treaty provides that if you have a judgment, a monetary judgment, you go to your national jurisdiction where you will file that decree and execute as if that judgment was issued by that court. But now when it comes to judgments that are directive in nature, you are asking a government to go and do this. How do you execute that? It becomes a problem. But we also must say we have instances where governments have actually executed without any follow-up. Once they get a judgment, they have respected it. Look at the case of BAT. Uganda government did it. But of course, I accept there are others also where governments have been directed to do things and they have not done it. Now, Article 38(2) of the treaty says every partner state must take all steps to ensure they comply with the judgment of the court. That means where a country, a partner state fails to do that, it is in violation of Article 38(2). That means it is a violation of the treaty and they can be challenged again. In fact, we had a case where somebody sued Uganda government was supposed to pay him some money. They failed to pay. He took them to court again, and the court said again that was a violation of the treaty. Eventually, they paid. The question is, how many times can you do that? So these are matters which we can look at in the future to see how do we amend the treaty to provide for proper execution mechanism. Of course, there are other things which we have in our treaty that are not in other international courts. For example, exhaustion of local remedies. You go to all international courts, they tell you exhaust local remedies. You come to EACJ, we tell you no, just come direct. Why? Because EAC is a people-centered and market-driven organization. So if it is people-centered, then the people must be given free access on how they can enjoy their judgments. This is something we will take up. So long as I'm still in EACJ, I'll not leave it. We'll see how far we can go. And I'll expect your support when it comes to that. Thank you.
Well, thank you, Your Worship. I think this is an area that we've been working on for the past almost 2 years now, issue of implementation of decisions. And I'm hoping, as you propose, it may end up at the level of amendment of this, the EAC treaty, to really be clear on how to best implement decisions. Now, there's one final question from Osiemo. She's asking about the relevance of other tribunals established by the EAC. The specific one she's talking about is the Committee on Trade Remedies under Article 24 of the Customs Union Protocol. What's its relevance in light of the existence of the EACJ?
Okay,
so in no particular order, Honorable Registrar, please proceed.
Okay, first of all, that tribunal has not been set up. It has only been provided for. As at when
David, you need to tell the registrar to unmute himself.
Sorry.
Yes, I was thinking I'm the one who lost audio.
No, it has not been set up, but it is provided for. And even if it is set up, it cannot remove the jurisdiction of EACJ. As you know, every tribunal is supervised by a higher body, a high court. In this case, even if those tribunals are set up, then EACJ will still be the final body to go to. In the event somebody is not happy with that tribunal. I know ELA members have been agitating for this to be set up for a very long time. We don't know, but we hope they'll be set up. That should not worry you to coming accessing EACJ. Thank you.
Thank you, Your Worship. Faith, any comment on that? And Mr. Simuyaba?
The issue of those tribunals to do with trade remedies, isn't it? If I had it well, right?
Yes.
I think that matter was litigated by the East African Law Society concerning the concurrent jurisdiction of the East African Court of Justice vis-a-vis other tribunals created. And the court, for the first time, opened the way for the East African Court of Justice to have jurisdiction over trade-related matters, despite the existence of the provision, as the registrar has said, of that tribunal, which has never taken place. This happened in the case of East African Center for Trade Policy and Law versus Secretary General of EAC, as well a similar case of East African Law Society from the same point. The court analyzed the articles 27, 30, Article 5, 6, 23, and 126, and came to a conclusion that there's nothing in those articles that would oust the jurisdiction of the court. And I think in that case, that is when for the first time we got light of the fact that matters to do with trade, customs, common market issues, and investment-related issues, we can file cases in the East African Court of Justice. So, despite the existence of those tribunals, the court still, as we said, has the overall role to interpret the treaty.
Thank you, Mr. Simuyaba. Any comment on this, Faith?
Yeah, just a quick comment, just to reiterate that these are tribunals. They are not tribunals. They are not courts. They are tribunals. And they'll fall under the supervisory jurisdiction of the East African Court of Justice.
Thank you, Faith. Well, I cannot see any other questions. So I would like to give the opportunity to our panelists, His Worship the Registrar, to make the final comments. and probably say bye to our participants. We've had more than 100 people who have faithfully stuck with us for the duration of this webinar. So thank you to the participants also, Your Worship.
Yes, thank you, David. I think these interactions give me information which I will otherwise not have. And I always share the feedback I get from here with our plenary meeting of judges, that this is what people are saying about us outside there. We need to see how to improve it or to correct it. Don't think any comment or any question is taken negatively. It is taken very positively, because this is the type of feedback we are looking for. But I will also like to see many lawyers practicing at the international level. Just like if you go outside Africa, how many of you in East Africa are registered to practice at The Hague, are registered to practice in the Strasbourg, are registered to practice even in arbitration tribunals in Geneva? There are very few. So do they take up our jurisprudence? We mostly practice here. Do they even take our jurisprudence? So let us start first by being active in our own international jurisdictions before we go out. It will give us a leverage for us to go and practice outside. The treaty is a document we're still working on, and we believe very soon, all going on well, amendments will come and we should be able to rectify some of these things. Thank you.
Thank you very much, Your Worship. Mr. Semuyaba.
Thank you. The organizers of this interaction. It has been very good. I would like to summarize by stating that me personally, I don't know why people have an impression that this court's orders or the court or its judgments don't work. To me, when I make a general assessment, it's a very good and international court. And because of its mission, as the registrar will tell you, it is to have a court of international, excellence or something like that, the way their motto is. I can assure you that when you get a court judgment from East African Court of Justice, it will be respected. I can quote several cases. The case you've talked about, Wani Santino sued South Sudan that they hadn't complied with proper election of EALA members. They went back and did it. That's compliance. The case of Nyang Nyong, it was electing EALA members illegally or wrongly. They went back and corrected it. We have in Uganda the Mbide case, where there were no rules for election of EALA members. When the court made a judgment, the parliament amended the rules. That was compliance. I myself, I have handled the sit and the Sebalu case. When we had a court judgment and the East African Secretariat was not paying cost, we filed the famous contempt of court decision, which is used, I see it being quoted a lot in Ugandan courts. The court gave a very good parameter of what the registrar has told us, the compliance of court judgments within the requirements of Article 38. Every partner state, even the Secretariat, has to comply with the court decisions. And there is an obligation not to do anything to escalate the situation. Tanzania, I think when they were sued about the construction of the road through the Serengeti National Park, they complied, they didn't construct. So I really wonder why people think or tend to think that the court's judgments are not respected. To me, on the general, tell me of any judgment which has not been complied with. The money judgments, for example, costs, because normally it is costs. What we normally do, and here in Uganda we have set precedents, they are there as reported cases. Even in Kenya, the Professor Nyang Nyong case, the lawyers went to the national court and applied for what they call prerogative orders of mandamus. Even here in Uganda, when you get a taxation of cost award, you come to the National Court and apply for mandamus. And the Attorney General has paid those costs. So I'll be the last person to say that the court orders of EACJ are not complied with.
Thank you, Mr. Semuyaba. Thank you for the assurance. So advocates on the platform, bring cases. They will be implemented. Do not fear that particular aspect. Faye, any last words?
Yeah, thank you, David. I think we need to note that the challenges that the East African Court of Justice are facing, they're not unique to these courts. We have similar challenges in our local jurisdiction, so to speak, like the issue of delay, so to speak, and enforcement. And just as Mr. Semuyaba has said, I think the fact that we don't have express provision on the treaty on enforcement does not necessarily mean that the member states are not complying. If you look at it statistically, if actually to draw the statistic, and I know Mr. Okubo will agree with me on this, most, if not all, most actually a majority of the judgments from the East African Court of Justice, they're complied with. And we have examples of high profile cases like the BAT case that was complied with by the government of Uganda. So that is a presumption that we need to check and see. We need to check and to confirm that there are no factual basis to that. Now, I also want to encourage my practitioners, my colleagues from the East African community, to expand their practice to the East African Court of Justice. This is an opportunity. It's still young, so we can develop and grow together, and just also to open up the way they are. It's an opportunity beyond our borders. It's a regional court. It's a very good platform. We actually have very good qualified judges from the East African community, and the judgments, if you may read, the judgments that come from these courts, they're quality judgments. We've even used some of those judgments back in Kenya. So there is no fear to venture out to do this. But I think what we need to do in our respective countries is just to be ambassadors for the East African Court of Justice. Most of the practitioners, our clients, so to speak, they're not aware of the jurisdiction of the Court of Justice. This is something that we can do. And at times, even the practitioners back at home, there are several countries, they're frustrated at times. Maybe for political reasons, they don't know, they think they don't have a remedy. Maybe they're fearful if they go to the local jurisdictions, the orders may not be given against the government. Think about EACJ. We've actually seen cases, of course, meritorious cases where orders have been given against, most of the governments in the East African community. So this is something that you need to think in mind. So when you're approached by a client, your options, your forums are not limited just to the national courts. There's a forum, the East African Court of Justice, where you can go and obtain a remedy on behalf of your client. And I'm hopeful, just like David mentioned and Mr. Kubo, that these challenges, practical challenges, but the East African Law Society, of which I'm a member of, together with the staff at the East African Court of Justice, they've been working together to see how some of these challenges can be addressed. And I'm hopeful maybe in a few months or so, this is something that we'll be having a different conversation in respect to some of these challenges. Thank you so much, David, for the opportunity, and thank you so much for participants that have stayed to the end.
Thank you very much for the vote of confidence in the court, in the process, and the implementation process especially. This has been a cause of fear among practicing advocates that if I go to that court, will I get the remedies I'm seeking? So we've been assured by practitioners who have appeared before this court that your claims will be properly addressed. So bring them, utilize this court, utilize its arbitration mandate. I think that is something that we've not mentioned in this session. There's free arbitration at this court. Utilize it, use it. Instead of taking your cases to New York or wherever else outside this region, use this court. It has so much to offer. Mention judges and it's not fully composed now, etc. You will still get your remedies and very much on time. So thank you very much, our panelists, your worship. Thank you for taking your time, Mr. Semuyaba, Ms. Masharia. Thank you so much for taking time off your busy.
David, if I may just mention
something. Please do.
Maybe it's something maybe we didn't speak to our attendees. Maybe they're thinking, how do I approach this, the East African Court of Justice? It must be expensive because it's a regional court, right? Maybe just to say, we don't have, I mean, the registrar will confirm, they're not filing fees. Unlike in our local jurisdictions, where you have to pay a huge amount of money to file a claim. You don't have to pay huge amounts of money to file a claim at the East African Court of Justice. You don't need to physically travel to Arusha to file a claim at the East African Court of Justice. We have sub-registries in the different countries, the East African region. So it's easily accessible, and it's so to speak, it's affordable, because of course there'll be other costs maybe for printing, but it's affordable in the sense that you don't have to incur filing charges, for example.
Thank you very much, Faith.
Very soon, you won't even have to travel to Arusha to have your matter heard. You may conduct your case from where you are sitting, the way we are. That's what we have been doing.
Thank you, Your Worship. I think there's a training that we'll be bringing to you soon in collaboration with the Office of the Registrar on the electronic filing system. We want you to know how you can actually conduct these cases from the comfort of your office in Nairobi, in Kampala, in Kigali, in Dar es Salaam, or wherever you are in East Africa, without having to use so much. The filing fees are free. There's no filing fees. So it's really a court that, unlike popular perception, it's actually very much affordable. So thank you very much to our participants from this training. All the presentations will be shared. We'll also share a link to our YouTube channel. This session will be recorded and uploaded there. You can relive this session by going back and checking things you might have missed. And if you have any questions regarding practice before this court, do not hesitate to send them to us. You can send them through the East Africa Law Society. They'll be shared with our panelists today, and they can be answered off-site, even if not now. So thank you very much. Have a good lunch and a good end of week. So thank you. I think we might declare this session closed officially.
Okay, thank you very much.